A patent is basically a monopoly, a really powerful tool that lets an inventor protect their creation. But what happens when that power is granted by mistake? Today, we're diving deep into the world of patents in India to figure out how a monopoly, once it's given, can actually be challenged. And this is the central question, isn't it? The whole point of a patent system is to reward real, genuine innovation. But sometimes a bad patent, one that isn't truly new or inventive, slips through the cracks. And that can be a huge problem. It can stifle competition and block access to really crucial technologies. So let's take a look at how the Indian system stands guard against this. You know, the system has these built-in safeguards, and you can think of them as 3 critical checkpoints. The first one is a check before the gate is even locked. The second is a chance for a second look right after it's been locked. And the third, well, that's the final veto, kind of like a master key that can be used at any time. Let's walk through them.
Okay, our first stop is pre-grant opposition. This is literally the earliest possible moment to raise a red flag. It's your chance to challenge a patent application while it's still just that, an application, not a done deal.
So what is it exactly? A pre-grant opposition is a formal challenge that gets filed after a patent application is made public, but, and this is key, before the patent office gives its final stamp of approval. Now, the most powerful part? Just look at who can file it. Any person. Seriously, you, me, a competitor, an NGO, absolutely anyone can step up and say, hey, wait a minute. Let's break down the strategy here, because this is really cool. The who is incredibly broad, right? It's basically a crowdsourced quality check on innovation. The when is crucial. It all happens in that critical window before any monopoly is actually granted. This makes it a proactive, defensive shield. And it's designed to be fast and accessible. Get this, there's no official fee to even file one. But what if a questionable patent makes it past that first checkpoint? What if the gate is already locked and the monopoly has been granted? Well, the system gives us another shot. Welcome to our second checkpoint. This one's called post-grant opposition, and you'll notice 2 huge differences right away. First, it has to be filed within a strict 1-year window after the patent is granted. The clock is ticking. Second, the challenger can't just be any person anymore. Now you have to be a person interested, which usually means someone with a direct commercial or research stake in that field. So here's the strategic trade-off, right? Pre-grant is your open-door, faster, cheaper option to stop a patent before it even exists. But once that patent is granted, the whole game changes. Post-grant is a much more formal, almost court-like process, and it's limited to a person interested within that 1-year window. And notice the biggest shift? With a granted patent, the owner can now sue for infringement. The stakes just got a whole lot higher for everyone. And now for our final checkpoint. This is the most powerful tool in the entire toolbox. We're not talking about a limited window of opportunity here. No, this is the master key that can be used at any point during the entire life of a patent. We're talking about revocation. It's the complete and total cancellation of a patent's monopoly rights. It can be started by an interested party or even the central government if they feel it's in the public interest. And this is really important. It can be used as a defense. So if you get sued for patent infringement, you can countersue to have the patent completely wiped off the books. So on what grounds can you actually make these challenges? Well, the law has a long list, but they pretty much boil down to these core ideas. You can argue the invention was already known. The law calls this anticipation. Or that it was just an obvious tweak on something that already exists, meaning it lacks an inventive step. You could also argue the inventor didn't describe it clearly enough for someone else to make it, or even that they flat out misled the patent office. Okay, theory is one thing, but how does all this play out in the real world? Let's look at a massive, high-stakes showdown that put this entire system to the ultimate test, and it all revolved around a life-saving cancer drug. So on one side, you have the pharmaceutical giant Roche holding the patent for its lung cancer drug Tarceva. And on the other, you have the Indian generic manufacturer Cipla, who decided to launch its own, much cheaper version. The stage was set for an epic legal battle. And this is what was truly at stake. Just look at the staggering difference in cost. Roche's patented drug was around $122 for a single tablet. Cipla's generic version, just $41. You can see, this wasn't just a business dispute. For thousands of patients, this was about access to medicine that could save their lives. So, Roche sued Cipla for infringement, obviously. But Cipla fought back using the very tools we just talked about. They countersued for revocation, arguing that Roche's patent was invalid from the start. Their court claim that this drug was just a slightly different form of an older substance and didn't really offer any significant improvement. In other words, it lacked a true inventive step. And here's the climax. The Delhi High Court refused to grant an injunction to stop Cipla. And the judge's reasoning? It went beyond all the technical arguments and invoked this incredibly powerful concept, public interest. The court basically decided that the need for affordable access for cancer patients outweighed Roche's claim to a monopoly. It's a perfect example of that crucial balancing act at the heart of the system. So, we've seen the 3 checkpoints, and we've seen them in action in the real world. Now let's just put all the pieces together for a final strategic look at the whole system. Okay, this is basically your cheat sheet for choosing the right tool for the job. Think of pre-grant as your early, low-cost strike, a way to stop a problem before it even starts. Post-grant is your more formal, focused challenge, but you've only got a year. And revocation, that's the ultimate power tool. It's flexible, it's available anytime, and it's designed to dismantle an undeserved monopoly. So why does all this legal complexity matter? Why should you or I care about pre-grant, post-grant, and revocation? Well, because it gets to the very heart of what a patent system is even for. And here's the most important point of all. These mechanisms are not just technicalities for lawyers to argue about. They are society's levers for finding a really delicate balance. On one hand, we absolutely have to reward genuine inventors for their hard work. But on the other, we have to protect the public from undeserved monopolies that block progress and limit access to life-changing innovations. Which leaves us with a final and pretty profound question. We grant monopolies as a reward for invention. But as that Roche's Cipla case showed us, that reward comes with a cost to the public. These gatekeepers, these checkpoints, they are how we, as a society, debate and decide that cost. They force us to constantly ask, what is the right price for innovation?